All right, good evening and Happy New Year. We're going to call the meeting to order at 6:04 p.m. This is the Town of Bay Harbor Islands quasi-judicial public hearing for January 9th, 2017. Pledge of Allegiance. Can we all rise for the pledge? Okay. Madam Clerk, roll call.
Councilmember Yaffe?
Here.
Councilmember Tricochet? Not here yet.
Marlene, just to let you know, she called earlier, just a couple of minutes ago, said she was not going to be able to make the meeting tonight, personal reasons.
Councilmember Sauber?
Here.
Councilmember Reed? Here. Councilmember Fuller?
Here.
Vice Mayor Bruder? Vice Mayor Bruder?
yes, here.
Mayor Leonard?
Here.
You have a quorum.
All right, we have a quorum. Okay. All right. We're going to start with item number 1.
Public hearing for the purpose of hearing any public comment with respect to an appeal filed by Attorney Tucker Gibbs on behalf of the 1060 Kane Concourse Incorporated, 1048 LLC, 1050 LLC, DNF LLC, owners of property at 1050, 1048, and 1050 Kane Concourse, and 1065-1073 95th Street regarding Church by the Sea at 1000 Kane Concourse. Site plan approval by the Planning and Zoning Board was on July 19, 2016.
All right, we're going to start.
Mayor?
Yes.
I have a brief disclosure.
Sure.
I would just like to disclose that in 2012, I was a party in a legal action, and Mr. Gibbs was our attorney, but we have not had any communication whatsoever about this issue. Actually, I'm sorry to say I haven't talked to you much at all, other than in passing when you're over here at meetings. And also to clarify that I have frequent conversations with Mrs. Newhut about town business, and I have accompanied her to the building department, etc. But we agreed immediately upon realizing that there would be an appeal that we would never speak about that appeal. I was very clear about it, and she understood, so there have been no conversations regarding this appeal. Thank you.
Okay. Rick? Mr. Gibbs? It's nice to see you again.
It's nice to see you all.
Yeah.
My name is Tucker Gibbs, and I have law offices at 3835 Utopia Court in Coconut Grove. And tonight I'm here representing a list of corporations. So it's 1060 Kane Concourse LLC, which owns the property at 1060 Kane Concourse. 1048 LLC, which owns the property at 1048 Kane Concourse. 1050 LLC, which owns the property at 1063 through 73 95th Street. And DNF LLC, the property owner at 1050 Kane Concourse. And as you all know, my clients are appealing the approval of the Planning and Zoning Board resolution.
Sorry about that.
That's all right. Resolution 2098, because it approves a project with a site plan that is inconsistent with Section 23-5, Paragraph 7 of the Town Code of Ordinances. And I wanted to read you the pertinent part of that, or most of that section, so you get an understanding of what we're talking about. It says, 100% of the ground floor space of any newly developed building or land facing Kane Concourse shall be used for the purposes set forth above. And that's in sections 23-5, 1, paragraph 1 through paragraph 6. And it's a listing of what would be permitted. And I'll go through those later on. Excluding businesses and professional offices, including but not limited to physicians, attorneys, real estate offices, medical clinics, and stock and commodity broker offices. Now, this is really important to understand that this property is the old, and you all know this is the old Ocean Cadillac site, and it is supposed to be demolished. So it will be a vacant lot when this for this project. And so the property, there's no reason why this property, this building cannot meet a zoning code, the zoning code provisions. The property is a blank slate. It's a vacant piece of land. It will be a vacant piece of land, and it's a basic matter of the building of this building on that vacant land consistent with the code. The applicant makes two arguments in its opposition to the appeal. It wrote a letter, and you all, I'm sure, have read that letter. And it says, essentially, that you must defer to your professional staff's interpretation of the ordinance at issue. And number two, that the proposed project meets the requirements of the zoning code, which does include section 23-5, paragraph 7, which is the basis of our appeal. But Florida law, and I'm going to go through each one of them, so I'm going to go through the deferential issue. Florida law is clear that you do not defer to the interpretation of your staff where that interpretation is contrary to the plain language of the zoning code. There are several cases that deal with this issue, and I'm going to quote two of them right now. The first case is Longboat Key versus Islandside Property, which is a 2002, I think it's a 2nd District Court of Appeal case. And it goes into this issue, and I'll be quoting it throughout my presentation. It says, as the wording of its laws binds a legislature, the town is bound by the wording of its code. That's very important. It is the wording of the code, it's the wording of this section, which is 23-5, paragraph 7. That wording is critical. It says property owners and residents have every right to depend on the wording of the code, because that wording is your statement. It's the law of this town, and it is your pronouncement to the citizens of this town what the law is. In Rinker versus Miami, a case that Mr. Price is very familiar with, that case is 1973 case, says the intent of the town council in its enactment of a zoning ordinance at issue is, quote, to be determined primarily from the language of the ordinance itself and not from conjecture based on another source. I'm not going to say Olunbe because I can't pronounce it very well. Here, the town planner decided, based on the other approved site plans with lobbies facing Kane Concourse, that the project is commercial across its entire footage and therefore meets the code.
You had it on, just
Give it a second close. Here we go. All right. What you have in front of you, and this is on the site plans you have, is is Kane Concourse up here. And, do I have it right? Yes, Kane Concourse, and you have an area here that is going to be used for, it's going to be leased out. I don't know if it's retail, what it is, but it's going to be leased out, assuming pursuant to the B1 code relating to Kane Concourse frontage. There's one part right over here, it's the easternmost part, that you will see, I have outlined in red just the paving, but it's this part right here that runs west to east, and that part right there has no such use. It has no use that is permitted under that section, 23-5, 1 through 6, or paragraph 7. And that is the lobby area. I want to be very clear. I'm not objecting to a lobby. I am objecting to a lobby on Kane Concourse. You also see this building faces East Bay Harbor Drive, which is also in the B1 district. There is no prohibition on the frontage on East Bay Harbor Drive having a lobby and access to that lobby. And for that reason, it is our position that when the code says 100% of the frontage, this code was written by your professional staff. The council voted for this provision, this legislative provision. It says what it says. It says 100%. This building is not 100%. It doesn't have 100% of the frontage meeting the requirement of section 23-5, 1 through 6 and 7. And that's our issue tonight. So when the planner for the city decided, based on the fact that there were, and this is in Ms. Huber's letter to you all, and it's cited, I think it's cited at tab J, page 30, line 17, and it's Mr. Miller's testimony. And it describes how he came up with his determination that this plan met the requirements of that particular section. And I'm paraphrasing, the town planner decided based on other approved site plans with lobbies facing Kane Concourse that this project is commercial across the entire frontage, that it meets the requirement with that lobby. Thus, his interpretation is based on his review of other approvals, but not the plain meaning of the code provision at issue. Because that code provision says 100%. And the only way it can be 100% is if it is 100%, and it isn't. I mean, that's essentially silly, but it's not 100% coverage. Now, he looked at what the town had done in the past, and said this, but in the Town of Longboat Key case, it specifically says, and I'm quoting, "The town's long-standing interpretation of its code," i.e. approving these things several times and having the planner rely on that. He said the court said the town's long-standing interpretation of its code cannot tie the circuit court's hand. And I'm going to talk about the circuit court because that's what the courts on the appellate court deals with, is what the circuit court does. If this was challenged in court, the court is going to will be limited like this. So when I use the word circuit court, you can put yourself in that position, because what you're being asked to do is to do something that I believe is inconsistent with the language of the code. So the town's long-standing interpretation of its code cannot tie the circuit court's hands. To allow such a result would countenance a shifting sands approach to code construction that would deny meaningful judicial review of the local quasi-judicial decisions. The meaning of a code would remain in flux. Such an approach does not promote consistency in the application of law. As the wording of its law binds the legislature, the town is bound by the wording of its code. This mounts a bulwark against the town's unfettered exercise of power. That means, in plain English, you have to read your code. You can't rely on how you all have interpreted it. It's the first thing you look at is the plain language of the code. If the plain language is understandable, and this is pretty doggone clear, it says 100%, and it gives you exactly what's allowed and what is within that 100%, then you have to follow what that code says. If you don't like what the code says, you're the legislature. You get to change the code. That hasn't happened here. Staff's position that the 100% requirement is met even though 100% of the ground floor is not used is allowed in that code provision ignores the plain language, and it should be rejected. The staff report is not competent substantial evidence because there is no factual basis provided to show compliance with the requirement for the 100% ground floor coverage on Kane Concourse of the uses set out in 23.5 paragraphs 1 through 7. In fact, the planner basically admits this in his testimony on Exhibit J on page 30, line 17 through page 31, line 3, when he says it's okay because other lobbies facing Kane Concourse have been approved. It's the old-fashioned adage that my mother used to tell me, 2 wrongs don't make a right. Just because you've interpreted the code one way for many years, and that way is not consistent with the plain language of the code, does not make that interpretation correct. Number 2, the zoning code specifically requires 100% ground floor coverage on Kane Concourse by those uses set forth in 23.5, 1 through 7. The plans show, this plan right here in front of you shows, there's not 100% ground floor coverage on Kane Concourses of those uses set out in 23.5, paragraphs 1 through 7. The applicant claims that the regulations regarding signs in lobbies, which does talk about B1 uses and does talk about signs in lobbies in B1 uses, implies that Kane Concourse B1 uses with lobbies can have signs. They can. assuming that those meet the code. And what I mean by that is, on Kane Concourse, you have an absolute prohibition, or said another way, you have specific uses that are permitted on the ground floor. But Kane Concourse is not the only B1 zoning area in your town. You have 97th and 95th Streets and East and West Bay Harbor Drive. That provision, the 100% coverage, does not apply there. The only assumption anybody can make is that language about lobbies used for signs references either legal non-conforming buildings that are on Kane Concourse that were built before this ordinance went into effect, or buildings on those other streets. You cannot infer where there's a specific language that this other provision trumps that, pardon my expression. So the applicant claims that the regulations and the signs shows that lobbies are permitted on Kane Concourse, which is in B1. This ignores the plain language of section 23-5, paragraph 7. It ignores that the B1 district extends to these other streets, 97th, 95th, and East and West Bay Harbor Drive. All this argument shows is that what is not allowed on the ground floor in Kane Concourse is allowed on the ground floor in the rest of the B1 district. Finally, the site plan speaks for itself. None of the B1 uses enumerated in 23-5, 1 through 7, as permitted on the ground floor of Kane Concourse are shown on the easternmost portion of this project. A lobby is shown, and a lobby is not included in that listing. It means that those uses not enumerated in 23-5, 1 through 7 as allowed on the ground floor of B1 facing Concourse are allowed on East Bay Harbor Drive. Therefore, we urge you to follow the plain language of your code, grant the appeal, and direct the applicant to come back with a plan that complies with that section. Thank you all.
All right. Mr. Gibbs, would your argument be the same if the house of worship sold Bibles or other religious instruments in the lobby?
No.
So if they wanted to sell Bibles in the
If there
lobby...
was a retail area, that had an entrance in there and it was just off Kane Concourse, like this says 100%, no, I don't think we could.
So, well, if they wanted to sell other types of religious artifacts and Bibles?
I think you have to have an interpretation, and I think you're going to get it's going to be very dicey, because if you have your planning or zoning person interpret your code that way, you may be opening up a lot of other things for a variety of sales that may happen. But the idea of having a church bookstore that is a real bookstore, like many churches have, a church, I won't say a thrift shop, but a church shop where they sell articles of clothing, like many churches do, that is, I think, something that is permitted under that section. But it would have to be, my view would be, it would have to be a store. It wouldn't have to be just like, you've got 3 books out here and they sit out there and gather dust.
Well, who determines whether 3 books is a bookstore or 50 books is a bookstore?
I guess it would be your code, and I think that would have to be something that your code would have to address.
Okay, thank you.
Excuse me, what about a kiosk? Instead of a bookstore, a kiosk.
But that doesn't work, because here's the issue. The issue is 100% coverage.
But a kiosk in a mall is a store.
A kiosk is, I think you're going to have some real serious problems with that. It's not my role to tell you all what to do.
You don't need a kiosk if you have an enclosed space that meets the building code.
Yeah.
And if the church desired to sell or offer for sale religious artifacts in that area, it would be a retail space, and therefore would, under Mr. Gibbs' argument, meet the test.
But not my argument, my response to your question. I don't want to be put in the position of saying that I made an argument to that end.
I
Because I certainly don't.
corrected, but a sale of religious artifacts constitutes a retail use, which is one of the designated uses in the code.
All right, thank you.
All right, I think at this time, Mr. Price, why don't you advise us what, I assume we're going to have Ms. Huber come up and... Which one?
The issue before you this evening is a very narrow issue, and as framed by the appeal document, it provides that Mr. Gibbs, on behalf of his clients, indicates that our code provides that on Kane Concourse in the BU1 district, 100% of the frontage of the property must be utilized with specific delineated uses which is contained in the code. Mr. Gibbs's argument is that a lobby does not fall within the ambit of those permitted uses, and therefore it is a violation of the strict interpretation of the code. I must also warn the board that we are dealing with a house of worship, and our neighboring city had a similar regulation in regard to restricting places of worship to the second floor of retail areas. And first, the federal court told the town of Surfside that their ordinance was a clear violation of RLUIPA because they permitted uses on the first floor which constitute places of public assembly, yet they preclude a house of worship going on the first floor. I've discussed this with Mr. Gibbs. Even if he wins his argument tonight, there's a good chance that he loses and everybody theoretically could lose, because the church could be entitled to be on the entire block on Kane Concourse, and probably would be upheld as, if we do not permit them to be there, as a violation of RLUIPA. And it's not a very simple issue with a simple result. Mr. Gibbs is correct. You can change the code anytime you wish. However, when you have outside illegal issues such as RLUIPA, which is the Religious Land Use Institutional Persons Act, the town has to be extremely sensitive, particularly in regard to what has happened in a neighboring community. And it didn't happen once. It happened a second time. And the courts have not looked on favor with municipalities restricting houses of worship to second floors of the shopping center. That's considered under the RLUIPA test an unequal treatment with other similar uses.
Okay. All right. So, all right, moving forward. So you're done, Mr. Gibbs? All right. Oh, you have one more. All right, come on up. Sure.
Stan, you had talked about the idea of the bookstore, but I don't know this, but I just want to put this out there. There's an issue of parking, and that may impact whatever parking requirements there may be. I don't know if it's a retail use. If you're going to, I just want to put that out there, that may be an impact in terms of parking.
That's a good point.
Okay. All right. I guess at this point we'll take comment. And
But I don't think they know they have to sign.
By the way, for those of you who are not aware of our process, if you wish to speak during this hearing, we have forms for you to fill out in the back. The lady in the back actually has the paper raised, so if you wish to speak, just fill out the form, and we'll call you in the order that you have brought it forward. And of course, first is Mr. Bruder.
As he's coming up, can I just get a clarification?
Absolutely, absolutely.
Either Michael or Stan or Ron. So, because I haven't been to any, this is the first time this is before the council, but and I didn't go to the planning and zoning board meetings. So the based on what Mr. Gibbs said, I understood that the entrance is on East Bay Harbor Drive, but there are windows on Kane Concourse which look into the lobby, but the lobby entrance is on East Bay Harbor. Did I understand that correctly?
No, I think the lobby entrance is on Kane Concourse.
It's on the corner. It's on
It's on the corner. It's on the corner.
It's on the side.
Yeah.
On this side. So
Yeah, I just want to clarify, it's on the side. But Mike can answer that question.
So
on the side or it's not on the side?
Mike, come on up, come on up.
Wait, Harry.
Let's, yeah.
Good evening, Michael Miller, Town Planner for the record. I brought a excerpt from the approved site plan. The issue for us, and when we're looking at this, is they've created a series of storefronts for the retail stores. At the corner, there's a open plaza. Then the lobby is down East Bay Harbor Drive, and all of the doors go onto East Bay Harbor Drive. There is no door facing Kane Concourse, and there's a open plaza at the corner.
Thank you.
Okay. All right. So we saw that. All right. Harry?
Hi, Harry Greeter, 1281 94th Street, Bay Harbor Island, Florida. First of all, I want to say Happy New Year's to everybody, Stanley, my fellow citizens, and to all your families, and Ronald, JC. First, I want to congratulate you guys. I've been here 22 and a half years, and I've never seen the state of the town in better shape. And I think it's a combined effort between this council and all you fellow workers. Property values are at their highest. The town's safer than it's ever been. The police force is tremendous. The schools, still one of the best schools in the nation. And Kane Concourse is coming along. Me, I would never live anywhere else. My children, this is the best town. To me, this is the greatest town in the world. And it's because of your combined efforts. I also like to say, I've been here for a lot of very sensitive issues. This is one of them, and very, very sensitive. And I've been through one that I personally was involved in, besides the development issue, which I have to say, looking back, when I was really in favor of big development, and one building came up 15 stories, and I look back at it, I was wrong. And I'm the first one to admit that planned development came out really, really well this time around, and that's a result of you guys. I also like to say there was a nativity scene that we had here not too long ago that I was right in the middle of, and one of my tenants was right in the middle of it also. And you know, it's always sensitive where, you know, it's just basically, you know, there's Jewish people and Catholic people and all kinds of people. And I still stay on the same stand I always had. And I believe everybody, Jewish or non-Jewish, is always entitled to their faith. And that's always going to be my stand. And I'm a Jewish person, but I really believe that we should invite all, you know, churches and synagogues to our town. You know, I really believe there should be a separation between state and government, and I always believe in that. I'm always going to have a lot of backbone. That's the way I operate, and everybody knows that about me. And so at the end of the day, it's a church. And if, you know what? If it comes out that the church comes here, it's fine. If it doesn't come out, it's the church. It should be the worst thing that ever happens to anybody in this audience. It really should be the worst thing. If you win, and your feelings are, if you win, it's fine. If you lose, it'll be fine. I promise you, it'll be okay. I've lost many battles. I've won many battles. I feel like I've done pretty well in my life. So at the end of the day, let's not get very, very vicious around here. Whatever the council decides, it'll be fine. And whatever it comes out, it'll be fine. And that's my feelings. Thank you.
Thank you for your comments. All right. All right, next up, we have Amy Huber. Happy New Year.
Happy New Year. I'm going to do my best to stay within the 3 minutes, but I may need a couple extra minutes.
Let me get an opinion.
This is quasi-judicial. She's entitled to, she's the attorney for the zoning applicant, and she's entitled to make a record.
Okay, so we're not going to count her time? All right.
Yeah.
All right, Jason.
Hi, good evening. Amy Huber with the law firm of Shubin & Bass, 46 Southwest 1st Street, Miami, Florida, here on behalf of the Church by the Sea. I'm joined by the reverends, as well as many board and trustee members, as well as members of the congregation. I actually think the issue before you today is very simple. And it all stems down to a reasonable interpretation. And Florida courts have long held that deference is given when there's a reasonable interpretation, and the only time you should overturn an interpretation is when it's either clearly erroneous or unreasonable. So I would ask all of you to look at the uses that are outlined. Multifamily residential, mixed use, business and professional, retail, personal services, miscellaneous uses, and restaurant uses. And ask you if you ever believed when you were drafting your zoning code and you knew that you had multi-story buildings, if ever in your wildest dreams did you think that a lobby wasn't a permitted use in one of those buildings? I don't know anyone that believes that a reasonable interpretation of a multi-use building would not include a lobby, and that a lobby would not be a permitted use. In order to overturn your planner and your staff's interpretation today, you would have to say that their interpretation was unreasonable and that a lobby wasn't a permitted use, and that you didn't intend for lobbies to be located within the business district along King Concourse. Your code doesn't say that 100% of the uses have to be retail or office. It's 100% of the first floor needs to be a permitted use. A lobby is a permitted use. No one has ever said otherwise. It specifically says that lobby access is permitted when you look at number 1. So if lobby access is permitted for multi-use buildings, why wouldn't, which include residential, why wouldn't a lobby access be permitted for a building that has a church on the second floor? It's an extremely reasonable interpretation, which is why your planner made it, and your planner has made that interpretation historically. This isn't something new. This isn't a new interpretation that he just came up with to try to thwart something or make... This is how he's always viewed the code. This is how your town has always interpreted this provision and applied this provision of the code. For you to now somehow change it would be seen to be doing something different to inhibit the ability of the church to operate, especially in light of the fact that the church is required to be located on the second story or above. In addition, the record is clear. We went to multiple DRC meetings. We had multiple planning and zoning board meetings. Your town staff found that we met all of the criteria of the code, including this. The planning and zoning board found that we met the criteria of the code, including this. No one said otherwise, and no one has ever raised the issue of whether or not a lobby was a permitted use until this appeal was filed. So we'd ask you to deny the appeal, uphold the approval by the Planning and Zoning Board. We believe that that is a reasonable interpretation and the only interpretation that can be made by this council. Thank you.
Okay. No more public comment? Yes. All right, well, you have to, come on. Are there any others? Any other public comments? No. Kathleen Kennedy.
Kathleen Kennedy, 9180 West Bay Harbor Drive. I don't understand something here. If I'm going to a church, I have to go through a lobby, right? So what's the BS? What is the problem here? You have to go to a lobby to get to the second floor. So I don't understand it. Really, I'm sitting back shaking my head. A lobby, you walk in, and then you go upstairs to the second floor to this, by the way, amazing Church by the Sea. I was there for Christmas services. I'm asking this council to deny this appeal. I think there will be an asset on the King Concourse. I've talked to just about every business person on the King Concourse, and they all welcome the Church by the Sea. It'll be good for everybody. And please deny this application, okay, and uphold the planning and zoning. Thank you.
Thank you for your comments. We also have Victor Maya.
Victor Maya. This church will fundamentally change the nature of our town. And it's not just a church. It is a school. It is a recreation area. It is a playground. It is a reception hall, a wedding hall. It is multi-purposeful, beyond just a religious institution. So there's a lot more that goes into this property and into this building than just a religious institution. And, you know, to basically just throw out RILUPA, which is not a part of this particular appeal, I think is a disservice to all of you, because there have been interpretations of RILUPA. The law is not new, and yes, there were decisions related to Surfside, but there are other decisions all across the 11th Circuit Court of Appeals, you know, that interpret RILUPA in many different ways, where there can be some restriction in terms of the scope of the entire building and project. And I think that that's what we have here. And unfortunately, this church has refused to have any meetings, despite being invited by you all and others to meet with members of the community to talk about their project and the scope of the project and what it entails. And I think it's very unfortunate that that's the case. As related to this specific appeal, 100% is 100%. Okay? There's no getting around it. It's not 99%, 98%, 95%. It's 100%. You know, and if it needs to get kicked back to planning and zoning, if they want to make changes, you know, so be it. But 100% is 100%. And, you know, if there was some kind of variance that they wanted, they could have come in and had a variance. I mean, the town has gone back and changed, you know, various, you know, provisions of the code, you know, to deal with issues that have been brought up by all of this. But the fact of the matter is that the scope of what you're reviewing is very, very narrow here. Let the chips fall where they may, but it's very difficult to find a way around or a loophole, you know, outside of 100%. So I urge you to grant the appeal. Thank you.
Terry D'Amico?
Hi, Terry D'Amico, 9101 East Bay Harbor Drive. I think that the attorney mentioned something about how the planner is interpreting, okay, the code. She mentioned twice that our planner is interpreting. He's also the planner for Bal Harbor. And I find that he's now looking at the same applicant, twice in two different towns. There's got to be some kind of conflict that our planner is working for both towns and trying to satisfy the code. One of the things, if you look at your floor plans, they have tons of rooms that are not identified as what they're doing. And in order to make everything about code is defined by use. So you have to define the use. So for all of them to say that this is the code, you know, they just changed the code, building code, that all classrooms have to be noted to whether there's 5 or 10 students, because it's all about exiting. We also have all these, dining. We have so much going on, and we're looking at our prime residents. But, you know, if someone really wanted to work together with the community, the easiest thing to do would be put the entrance on the back of the building or on the side. But I'd rather see it on the back, so it has some kind of nice grandness to it. Because you're taking up the commercial district. You look at planning, you can put it there, but you have to be more sensitive. Why don't you leave the corner you have? Put the entrance in the back and work out the parking and everything that's going to change us. This is going to define, as Victor said, our neighborhood. And this has been a hidden process. I know it's basically they got all of your somewhat approvals or nods because they showed you behind closed doors before it ever came in front of us, in front of the public. So we should have been all a part of this. And you should definitely, this should be retail commercial. And just put the entrance somewhere else and work it out, because you're going to kill your biggest resource for revenue is your commercial district for retail and offices. Thank you.
Any other public comment? Mr. Gibbs?
In rebuttal, Tucker Gibbs, Ms. Huber brought up two issues: a reasonable interpretation, that this was a reasonable interpretation, and that she talked about the list of permitted uses. I just wanted to say a couple of things. A reasonable interpretation is looking at the plain language of the ordinance, following what the words say. I didn't want to have to do this, but I'm going to do this because your ordinance is specific. Your ordinance specifically and exactly says what is allowed in B1. There's a list. 1, multiple family dwellings, including condominiums, rental apartments, townhouses, lofts, and similar dwelling units, provided the residential uses are part of mixed use. And it says lobby access is permitted. That's what it says for these uses, these residential uses. 2, business and professional office uses, banks, savings and loans, business and professional offices, medical offices and clinics, stock and commodity broker, employment agency, or similar uses. Not one mention of whether or not a lobby is permitted for that use. Now, they allow it for residential. They say nothing for offices. It's pretty interesting for an office building. But they don't allow, you all, or whoever, don't allow it. This code doesn't allow it. Retail uses, clothing, wearing apparel, neighborhood grocery stores, liquor and wine sales, tobacco sales, stationery, shoe sales, and repairs, luggage and leather goods, sporting goods, electronic and music sales and service, telephones and communications goods, computer sales and service, optical and eyeglasses, office supplies, florists, drugs and sundries. Again, I don't think you're going to have retail uses with a lobby, but you might. No mention of whether a lobby is allowed. 4, personal service uses, barbershop, beauty shop, skincare, day spas, dog grooming salon, nail salons, wigs and hair, fitness, exercise, weight loss, yoga, and meditation center. No mention of whether a lobby is allowed there either. And then we get to miscellaneous uses. It isn't just a section that says miscellaneous uses. This section defines what are the miscellaneous uses. It says miscellaneous uses: antique display and sales, jewelry sales, sales and repairs, furniture sales, confectionery ice cream store, bakery and pastries, art galleries and studios, auction house, post office, theater, and hardware store. That's your miscellaneous. It's not open-ended. And again, no mention of whether or not you need a lobby. And number 6, the final one. Restaurant uses, sit-down restaurants including indoor, outdoor, and sidewalk cafes, coffee shops, sandwich shops, except that no fast food shall be permitted unless approved by the town council. And then it defines what a fast food restaurant is. Again, no mention of a lobby. So when you're being told that the interpretation of the planner is to be given deference, when the planner ignores the plain language of this code. Lobby is not mentioned. When the attorney for the church specifically says that because a lobby is allowed for a residential use, not for a business use, that means a lobby is used anywhere. For a church, for offices, for anything else. It does not say it. If the code doesn't say it, it is not allowed. And it says here specifically, permitted uses in B1. And it says, this is what it's for. It says, should not be used or occupied for any purpose excepting for one or more of the following uses. That's all it says. It says, this is it. And a lobby ain't there. So, when you're talking about deference, yeah, you give deference to the Word. The Word is in this document that this council passed. The other thing is that I want to make it really clear. I heard people talking about what this appeal is about. This appeal is about something very simple. It's a zoning appeal. It's not about a church. It's not about whether a church is permitted here, allowed here, not how a church is being used. It's about your zoning code. This is a site plan approval that I'm appealing for my client. And that's what this is about. So I want you all to focus as I said, I don't want to be a preacher, pardon the pun. You're going to focus on the Word, and the Word is written here, in your code. Thank you very much.
Isaac,
Yeah. Stan,
Yes, sir.
first of all, I want to read something for the record, what the definition of a lobby is.
Yeah.
And a lobby is a room providing a space out of which one or more other rooms or corridors lead, typically one near the entrance of a public building. In your opinion, this plan complies with our code, even to the strictest letter?
My opinion, sir, is that if you rely upon the testimony of your planner, I believe your position can be easily defended.
I have a question for Marlene. To the best of your recollection, do the buildings at 1005 Kane Concourse, 1019, 1035, 1045, 1170, 1160, 1166, 1150, 1128, and 1108 all have a lobby?
I believe they all have some sort of entrance and some sort of lobby, yes.
Okay. And just a quick word about defining or redefining our neighborhood. You know, I spoke to some residents that live either directly across from the Cadillac Place or down the block from the Cadillac Place. One of the residents is my own son, who has residence across from the Cadillac Place. And if this plan is approved and the Cadillac Place is knocked down, what we're losing is basically a garage that was built across the street from these residential units, because that side of East Bay Harbor Drive between 96th and 95th Street is basically a garage where cars are fixed, where cars are washed, where cars are stored. The use right now of that property is equivalent to the most industrial use in the center of Miami. And from what I heard from the residents that live across the street from that property is that they wouldn't miss having that garage across the street from the house anymore, as opposed to having, a beautiful structure, with a social hall and schools and other programming going on in it. So, I, for one, will vote against this appeal.
All right, hold on. Is there any other public comment? Because if not, we're going to close public comment. So I want to give anyone an opportunity, final opportunity. All right, we're going to close public hearing. We're going to go to number 2. Mr. Manager, can you read number 2?
Discussion and possible action with respect to the appeal filed by Attorney Tucker Gibbs on behalf of his clients at 1060 Kane Concourse, 1048 LLC, 1050 LLC, DNF LLC, regarding site plan approval in the Planning and Zoning Board on July 19, 2016, of the Church by the Sea to be located at 1000 Kane Concourse.
Okay. All right, let's start down the aisle. If you have any comments, Kelly.
Mr. Price, can you please briefly outline what our charge is here tonight?
Yes, you have an appeal filed by Mr. Gibbs on behalf of clients seeking a overturning of your planning board decision, which granted a site plan approval. Part and parcel of that site plan approval was the permission to place a lobby area on the corner of Kane Concourse, and Mr. Gibbs' position is that the code restricts all frontage on this area to uses delineated in the code. And it is his opinion that a lobby is not a delineated use, and therefore it's forbidden, and therefore the site plan should not have been approved. Mr. Miller, who is the town planner, has given his interpretation both at the planning board and here again today, indicating that he believes that it is a reasonable interpretation to permit a lobby to be on this roadway, fronting this roadway, And that lobby is a permitted use under your code based upon his reasonable interpretation of the code. The issue of whether this is a church or not a church would generally not have any bearing upon your decision, but it is quite obvious that based upon what has been communicated throughout this town for the last several months, is the issue of whether this town has the ability to dictate that places of worship must be located only on the second floor in the commercial district. And as I have pointed out earlier, similar regulations in the town of Surfside have on at least 2 occasions been stricken by the federal courts as a violation of the RLUIPA law that indicates that it is not an unequal treatment with other similar places of public assembly. And what I want to note that one of the uses that Mr. Gibbs read to you is a movie theater, which is also a place of public assembly, which is not relegated to the second story of a retail use. It's permitted on the first floor. And that, in and of itself, is probably a violation of RLUIPA principles in that all uses are not treated on an equal footing.
Are we permitted to consider that tonight, or do we have
Well,
to simply consider the lobby?
I am informing the council that there are ramifications of approving this appeal. And those ramifications could have financial detriment to the town.
So, let's say this appeal is denied, and the appellant chooses to take it to the next step, to go to court.
Yes.
Does the town, is that between the appellant and the church, or is the town involved in that?
The town has the choice of whether to be involved in that case. I will tell you that most jurisdictions defend their decisions, but that is not a requirement.
Thank you.
Can I ask something? In all the buildings that Isaac named, was there ever an appeal on those buildings? Did anybody, have an appeal or an objection to the lobbies in any of those buildings?
I'd have to ask the town historian. I'm not...
Most of those were built prior to the passing of that, except for 1070 Ken Concourse, which has a lobby on the entrance.
And did anybody ever appeal that building?
Not that I'm aware of.
Thank you.
I can respond as the town attorney. There's not been an appeal in the last 40 years, including 1070. No appeals.
That's the real town historian.
And Craig, that has, Craig, when that went to planning and zoning, it went through the code, and Marlene, when that building went before the planning and zoning, I'm assuming they also looked at the code, and it was approved, and at no time did anybody have any objections to that lobby, correct?
No one has ever raised the issue of a lobby.
That was one question. Let's go. Let me tell you, let's not harp on 11-7, because he had presented one plan,
other issues,
and then, completely, changed his whole plan and made it, twice as large, and...
Yeah, that was a different...
Let's not talk a lot about 11-7.
Right.
It has a lobby. It's suffice to say that it has a lobby.
Thank you.
All right. Any other questions? No. Josh, you want to go?
Not questions. I'm going to make a few comments.
All right.
I mean, the problem here is I think there are valid points on both sides, and I'll tell you a couple things I have an issue here. I think a few things were poorly handled. First of all, I'll start with Mr. Miller. Whether there is a conflict or not, my thought process here is at the very least there is an impression of a conflict. I don't think you should have been the one working on this. I really don't. Just for how it comes across. Secondly, to the church, there were plenty of opportunities that were offered to you, just as any applicant would be,
to come and speak to the community in general for any large project. I wish you had taken everybody up on that. It would have, Amy, I think it would have been a good idea. That being put aside, my thought process is as follows. This is not about it being a church. This is not about whether or not something is good or bad for the community as far as what it actually is. This is simply a question as to whether or not we're following code or not. That's it. That's all that's before us today. There is no other question. And I understand people that will believe that there will be a fundamental change to the community for any large project. That's a valid point. But that's not what we're here for tonight, and that's not what we can actually look at. That being said, I mean, I've gone through the plans, I've read through the materials, I've read through, all the testimony. The fact of the matter is, what we have here is no direct access on King Concourse. It is onto the side. There is no possibility for any development to ever come up where we don't have some form of a plan of access. That's a fundamental thought for anything. We're not expecting people to grab ladders and go up to the second story. You have to have access. And the fact that it's somewhat located near the front of the building, closer to King Concourse, does not mean it is actually on King Concourse. The building itself, is it a perfect design? No. I have my own thoughts on it, but, and there are certain things that I like, certain things I don't, but that's not what we're here for tonight. The applicant may truly believe that this is in violation of the code. I don't agree with that. I do believe here that the access is necessary to get up to the second story, and as long as there is no direct access onto King Concourse, I can't agree with the applicant here.
Before the next speaker speaks, I just have a question. Can you explain your comments about, conflict of interest here?
Not my conflict of interest. I just don't like the fact that we're talking about there is a pattern, one project, let's just put it this way, one project in a neighboring community is affecting this one. There's a chain of events. And whether or not there's a conflict or not, there is an impression. I always have the belief that you should do whatever you can to be as open and to make sure that there is absolutely no possibility that anybody sees any form of a conflict. And Mr. Miller, I know you mean well by everything, and I highly respect your work that you've done for years here, but you knew that there was going to be a possibility of somebody coming up and saying that you're working in a neighboring community for a specific project that is by domino affecting this project, regardless of what the project is. And I think the proper way to address that in this instance would have not been to work on this part of the project. That's my thought process.
But, Mike, can you come up here for 1 second? Because this kind of took me for like a little bit of a curveball here. Can you define further what Josh is saying?
I'm a consultant planner, just like there's consulting engineers. Attorneys work in multiple cities. I work in multiple cities.
So
I happen to work for the community of Bal Harbour Village. I happen to work for the town of Golden Beach. I happen to work for the city of Lighthouse Park.
But you don't work...
The list is long.
But you don't work for the Church by the Sea, do you?
No. In my role in the village next door was to review plans for the expansion of the Bal Harbour Shops.
Okay, so
the Bal Harbour Shops...
Don't even say anymore. You're not employed by Church by the Sea. You're not a member of Church by the Sea.
No,
I don't understand what...
Nor am I implying that he is. Nor am I implying he is an employee of them. But what I'm saying is, there is a valid view that there is a potential that he's looking at, when there's one project that affects one neighboring town and comes over to the other, just the impression alone, the safer way to do it would have been to step aside for this particular project. That's my... Look, I'll just tell you right now. And if I ever have something, whether in my professional status or here or anywhere else, where there's a possibility where I think there might be a view of a potential conflict, I step aside because I don't want to have that impression. And I think it would have been a smarter move for you to do it that way. That's my thought.
All right, well, we're going to move on from this, but just for the record, I don't think you were on council, but this issue came up previously about Mr. Miller being in the employ of the neighboring village, and I did bring up an agenda item to have it go out to see if we wanted to retain different...
No, I don't have a problem with the more...
Really
I'm not talking about one subject. I'm just saying it's...
All right, okay.
The impression itself is...
Well, All right, so,
My comments are few at this point because most of my colleagues here have said what I would want to say. As has been repeated multiple times, this is a very discrete, narrow issue simply regarding the lobby, not regarding the use of the property. The fact of the matter is that we have, at the next Planning and Zoning Board meeting, an office building coming up for approval on the corner across from where the church will be. We have a hotel on the other corner, which is quite a large facility. On the other end of town, we have the Monarch Hotel, which is quite a large facility. And the store, I refer to as the store building, has apparently just changed hands, and that property is going, well, I'm not saying going to, but is likely to be redeveloped. So the point is that there have been a lot of changes in this community. There will continue to be changes in this community. I don't like all of them. Some of you don't like all of them. Some of you may like all of them. But, that's just a fact of any community, that there are going to be changes, and some of those uses, will change the so-called small town, atmosphere that we've enjoyed. But looking just at this particular project, it doesn't matter whether it's a church or anything else, and any other ancillary uses that a church or other house of worship may have. The only issue is whether that lobby area, which has a couple of windows which face Kane Concourse, violates the code, and I don't believe it does.
okay. All right, yeah, did you want to say something else? I thought you already spoke. Okay, so you didn't. Okay, well, all right, I'll be brief. I think most of my colleagues pretty much said it. As much as I appreciate seeing Mr. Gibbs and you speak eloquently, I don't think you reached the merit of the argument that it's on King Concourse, to be quite honest. I think I don't see any reason why we would approve your appeal. That's pretty much it. Other than that, just on a side note, I know that you eloquently mentioned that it's not relative to your argument that it is a church and Arupa, but it is the 800-pound gorilla in the room, and we all know this. That's why everyone's here. And the idea that this is the matter at hand, and I know that for those that are attorneys are going to look at it in that strict guideline, and for my decision, I am looking at it in that strict guideline, but we should also keep in mind that, it is a church, and I don't think that it is unreasonable to have a lobby, considering the fact that it is facing East Bay Harbor Drive. That's the entrance, as it was mentioned by our attorney and our town planner. So I don't see anything wrong with it, and I don't think that it goes against our code. That being said, I think we should have somebody call for a vote, and...
I'll move it.
Okay. Well, I mean, move it what?
I would like...
You have to make...
I have to make a motion.
Yes.
Okay, I make a motion that we deny the applicant's appeal.
Okay, can I have a second?
I'll second it.
Okay. Madam Clerk, roll call.
And to be clear, we are voting for the motion to deny.
Yes.
Just so everybody understands. Okay.
Councilmember Yaffe?
For.
Councilmember Saber?
For.
Councilmember Reed?
Four.
Councilmember Fuller?
For.
Vice Mayor Bruder?
Four.
Mayor Leonard?
4.
Unanimous.
Okay. Item number 3, Mr. Manager.
Public hearing for the purpose of hearing any public comment with respect to an appeal filed by Attorney Amy Huber on behalf of Church by the Sea, owners of the property at 1000 Kane Concourse, regarding this Church by the Sea site plan approval by the P&Z Board on July 19, 2016.
Okay.
Let me ask actually one thing before they do.
Yeah.
Come up. I want to ask, by making this appeal, is the applicant opening themselves up to other issues that we may have with the building itself?
I don't understand. Our appeal will speak for itself.
The answer is yes.
Okay, I just want to be clear.
I'm not quite sure what Mr. Price
he wanted to know the ramifications of hearing your appeal. That's what he's asking.
That opens me up to other things?
No, whether you were opening up the town to other arguments.
Against some of the designs of the building. In other words, if there's
No, the
something
design
else-
of, I do not believe that the design of the building is before you. It's
Well, that's what I was asking.
I'm sorry, I didn't...
That's what I'm asking. If there's
No,
anything else-
Her appeal is limited to exactly what she's appealed, which is not the design of the building.
That being said, Amy Huber, I'm with the law firm of Shubin and Bass on behalf of the Church by the Sea. In light of what just transpired, I would like to ask for a 60-day deferral related to our appeal. In the event that no further action is taken, it's the intent of the church to withdraw its appeal and to move forward with the condition as it stands. However, in the event that there is not a resolution, we do fully intend to move forward with our appeal. So I would ask you all to grant us the 60-day deferral at this time.
Okay. Would someone like to?
Could someone highlight for me?
Yes.
What are the ramifications?
Ms. Huber had spoken to town officials prior to this hearing and had indicated that if Mr. Gibbs' appeal was denied, she did not want to go forward with her appeal. She didn't feel a need to do that. And in order to protect herself in the event there is a judicial action filed in regard to the first item, she wants to reserve her rights to come forward here within 60 days. An appeal must be filed within 30 days of rendition of the decision of this council, which may take 15 days from now, may take 20 days. So she has built in a buffer that in the event that there is no further appeal, I believe her intention is at that time to withdraw the appeal.
What is involved in the rendition of the council's decision?
Well, it has to be signed by the mayor, recorded with the clerk. That's what rendition means.
Thank you.
Okay. All right, so...
Okay, I'll move.
Oh, one question. What is your opinion for the best interest of the town?
I suggest you accept the request for deferral.
I move that we accept the
I
request.
second it.
Okay, can we do it on a voice vote? Okay, all right. All those in favor?
Aye.
Anyone against? All right, ayes have it.
All right, the matter has been deferred for 60 days.
You got it.
Do we have a date certain so we don't have to re-advertise?
Can we, let's see,
Let us re-advertise.
yeah, we're gonna do it anyway, because that...
Thank you, have a good evening.
No problem. Yeah. All right, so there's no...
Second.
All right, all in favor? Aye. All right, we adjourn at 7:12. We're gonna start back up in 10 minutes.